thing, and we test everything with our own
Right.
independent experts. So
Okay.
I want that excluded too. That was in
Hello,
the motion.
guys.
All right. So with
First, I want to say hello, guys. Thank you. I want to introduce myself. My name is LJ Hall, and I am thanking you so much for being with me right now. You could be anywhere, but you chose to be with me. So if you decided to do this in the future and you're not with me now, or you just happen to run across me and decided to give me a look-see, I appreciate you. I really do.
thanking you so much
Woo!
for being
Okay.
with me right
So
now.
I that was me listening to me. Ain't that sad? I'm new to YouTube, so I'm new to live. I've done other YouTubes. So I promised myself that I was going to do a live before my birthday. Tomorrow's my birthday. So I don't believe in lying to myself. So we're just gonna listen to Lawyer, Love, and go into this YSL trial. And then once we get through this thing and I can get these controls together and figure it out, we'll backwards and talk about this warning, which led to this moment right now. Let's take a look.
With regard to that's two entirely separate.
The issue, I realize, is way late discovery is what is being alleged. But we're talking about two different sort of pieces of evidence. So with regard to this Boyer plotting of wherever the cell phone location is, the state has represented that they do not intend to use this. I'm granting the motion limine with regard to particularly is at least this case in chief, but with regard to if it potentially needs to be used in rebuttal, at this point, y'all are on notice.
Yes, it should have been produced before now, but we're also, I would
Attorney
say,
Love
pretty
was
far
listening to
away
people
from
yesterday about them pants and that
hearing
skirt.
any evidence
So she
about
done
the
pulled it
Grace murder
together. I like
anyway.
the
I
jacket.
am not going to make a blanket ruling.
I keep
at this
cutting off my
point
mic because
that
I don't
it
want you
can't
guys
come
to
in
have
and
the buzz
rebuttal
or the
either,
reverb for it.
because
So
y'all got time. I don't know if it
might need to be used or not. I don't know, but I'm going to leave that for another day if and when it does come up. Now, with regard to this second sort of chunk of information that's just been produced, Agent Bernie's analysis of what does that have to do with cell phones too, or just the incident?
He's a cell phone expert, so that's what it deals with.
Okay.
It's
As
April
to
20th.
the, okay. So what do you say as
to that.
okay, so I didn't pay attention to earlier that Love normally she be looking like she pulled her clothes up off the floor, but today, and it might be because up and down in these seats. I'm not body shaming because I'm a thickums myself. I'm a big girl and proud, but sometimes we have to pull it together. But today she pulled it together because yesterday she was leaning on her shoes. Her jacket was really wrinkled. As usual, I don't see her computer on. That woman never is together and has her computer on, which bothers me. But I'm going to go ahead and we're going to listen to more of what's going on. Let's see.
Ms. Love, because if y'all have already presented your evidence, or what's your plan with regard to Agent Bernie's report and analysis?
Your Honor, would the court permit me to address the first part regarding the Boyer records and tender the evidence and then address
Yes.
the second
Yes.
part of the motion? Okay. So the state is tendering for the court's consideration states 2A Boyer records, which is the affidavit for the search warrant, and states 2B Boyer records, which is the search warrant itself for the cell phone records. And the court is correct. We stated earlier and state again that we are not attempting to use them in our case in chief. As well, Your Honor.
Okay, she ain't attempting to use them, but she tried to slip it in. She tried to slip it in. It's just the fact that Bryan caught her.
Boyer records.
Mm-hmm.
It is a screenshot of a search of the wiretap data for the number of calls that involve 470-957-2893, and the number of calls within the wiretap that involve this number are 501. So
Okay.
I'm tendering this for
Okay.
the court's consideration.
All right, thank you. And 1 as well as 2A through C are admitted.
Okay, turning now to the first set of plots regarding the Little Wayne bus shooting, the data, the cell phone records, and their cell site location information.
So I am using OBS, and I don't know how to flip the controls and deal with my mic. Like I said, guys, I am new. I am trying to cut it down, but I'm hoping it doesn't cut down. I'm hoping it doesn't cut down the volume of the trial for y'all. But what happened earlier? Let's rewind to yesterday. Bryan still said that he was going through the paperwork that was emailed over, and he noticed an unknown phone number. An unknown phone number for a guy who is in jail in DeKalb County for shooting up a gas station. Like he's like literally sitting there for murder. And I think 2 other people got wounded. I don't know. Again, guys, disclaimer. I ain't an attorney. I ain't trying to be one. I'm just a girl with a few minutes on my hand who want to sit here with you and talk about this trial because Miss Love has been driving me absolutely bonkers through this thing. And, you know, there's some things on my channel I want to do too.
I'll get an exact date.
Give me a ballpark.
Miss Love needs sticky notes. She need to be writing things down on her hand. Oh, she almost slipped. She pressed her skirt today. She must have watched herself on YouTube. She had to have, because they was dogging that woman out on YouTube yesterday. Talking about her clothes and her nails. I'm going to be honest. I said her and Fonnie Willis got to share the same closet, and they need to leave the dress barn alone. I'm a big girl. I can say that. Okay.
January, June, April. Okay.
Let's go back.
So at some point
After April.
Yes.
Okay, let me ask you this. At the point in time when you think it might be relevant to have a plot of whatever cell phones might have been involved, we've already heard everybody's testimony. Man, we'd like to shore that up with some expert rolling back in here and taking the stand again. We're going to get him to plot this. Would it have been possible at that point in time to share with the defense, hey, y'all, we're going to have our expert that y'all already know about anyway. Go ahead and plot this too.
Yes, that would be.
Okay. Why was that not done?
Woo! Oh, I'm sorry. I'm too loud. I'm too loud. They keep asking this woman questions that she can't answer. Why didn't you tell the defense that you were going to circle back around and plot the phone calls from a guy that you know is in jail? You know where he is. You ain't got to look for him and transfer him like Woody. I'm telling you, yesterday Woody said while he was on the stand that he knew something about a car and somebody who was not being prosecuted for the murder. Let's go back and listen.
So, Bernie did not testify about these. He has. Okay.
She never has an answer. She don't, you know what?
Give the court
She gonna ask for 2 minutes.
More precise.
She
comments that we got
she
from
gonna
Not when you asked for them, not when you got them. When you asked for them.
that. Yes.
she's gonna ask for a few more moments, and I
Before
want you to
go to
watch
that
Judge
second question,
Whitaker's
of course,
face. Whitaker.
Okay.
She's so annoyed by her.
Go ahead. How long is it going to take to get that information? Can Mr. Christian work on getting that information?
It's already being worked on. I already.
Okay. I mean,
Okay, I gotta take that back.
And when did you ask for that?
She asked her when she asked for information.
I'll get an exact date.
Give me a ballpark.
She never has it together. This is why I decided I wanted to go live too, because I have some real concerns being a mother of a son, you know, who's an adult now with his own issues and troubles. Ain't my problem. But
In the last 6 months, that's
All right.
give you a narrower ballpark because things were delegated and we did.
Okay.
she
When did
never
these
wants to
people
take the, she never
testify
takes,
to the
she
Little
takes,
Wayne shooting? When was that? Okay. And when did you ask?
she takes all the credit for anything that good that happens. And she's a bully. She likes to on to everyone. I hope my mic is on. However, when it's time for Miss Love to take some accountability for the downfall of her team, because she is the one supposed to be leading her team, she never does it. It never happens. She always talks about how she delegated. Well, part of being a person who delegates authority is being able to also keep up with the things and keep abreast with the things that are happening. This trial is the most expensive trial in Georgia. Fulton County Jail, the guys are sleeping on the floors and in things called boats, all this other stuff that's going on, that money for Fulton County could be poured into. However, they decided they wanted to pour it into a racketeering trial, a RICO trial. I said racketeering, a RICO trial. We have to realize, though, there is a young man who's dead and whose family is hurting through all of this, and I get that. So maybe a murder trial would have been better to have had than having someone for a RICO trying to pull them all together. Maybe that would have been a better use of her time. But instead, the tax dollars are going into this trial and nothing to fix infrastructure or that actual jail. But I'm gonna go back. Let's get caught up. Let's get in here.
The court, since that is the motion on the floor, denied the motion because the data that has been plotted has been in the possession of everyone. That's including cell site location.
Guys, subscribe if you pop in. Just give me a little love. I'm new. I appreciate you though for popping in. Thank you.
For the defendant is correct that Judge Glanville said turn over everything that you have. And you have a continuing discovery operation.
Right.
So, moving to exclude a summary of what has already been given, we would argue is an extreme remedy given that the information that is contained in that plot that was given to them has been in their possession since July of 2022, and this is something.
Yes, I am nervous. I am nervous. This again, this is my first live, and I'm not really sure how it's gonna go. I'm just hoping that people pop in, say hello, chat with me.
Mr. Bernie did, is that with regard in the report that's come back? Is that in regard to the Donovan Thomas murder?
No, the plotting that they're referring to has to do with the Little Wayne bus shooting.
Oh, right. Y'all told me that. I'm sorry.
That we put up the evidence of.
All right. So, have you had Bernie testify yet?
No.
So, when he
I see on your witness list that you've most recently provided to everybody, that Bernie is listed as your expert, or not, he's unarguable, expert with an expert report and phone records for count 2.
That in the next 30.
Dominant. Okay. So is he then listed again for where?
Yes, he's not in the, he's also,
I shouldn't be looking at myself like that. My birthday's tomorrow, so I'm getting my hair done.
Different act.
It's just that.
Hi guys, thanks for dropping in on me. I appreciate it.
Okay, so are you planning to call him to say, and here's the plot of everybody for the bus shooting?
No, what we did was we introduced Detective Racy to do that, but the defense challenged Detective Racy's ability
She's so
to do
sneaky.
that.
Okay.
And so, for that reason, we
She's so
had
sneaky.
Agent Bernie to plot them.
Okay, so Gracie had already, you had attempted the plotting through.
Hey y'all, chap into the chat. Tell me something. Say something. Say hi. Say something. I appreciate you guys for popping in here.
That witness.
Yes, we had introduced, we introduced and attempted to introduce plots of various numbers. There were challenges to Racy's ability to plot various numbers. There were
Okay. So she's saying that another detective had limited abilities to track these numbers, but he was an expert. So for a backup plan, and that's just me interpreting, a backup plan was this new officer who is tracking on a warrant that the state knew they had this warrant, guys.
All right, but you had no
They
point
already
after
knew.
you couldn't
Hey,
get it in through Gracie said, all right, we may be trying to get this in
pop
through
into the
Bernie.
chat,
No,
subscribe and like.
no,
I'm new.
never did that.
Come on now.
And I
Help
want
a
to be
sister
clear
out.
that it had to do with the line of questions that were put upon Agent Racy.
Okay, so I mean, sure, it only came up that this was a possibility after Gracie testified.
We only decided to do that after that. We were intending to be done with that.
But it's still been 2 months since that time.
Yes.
And so why is
2 months.
an appropriate sanction not at
2
this point
months.
saying you cannot use that information through
2
period?
months.
You can't use that information. I can't
Now she
let
had it
Bernie
longer than
testify.
that, but 2 months she's admitting that she knew she was having this tracked.
Remedy
Now,
of
all of those
exclusion,
lawyers could have used
as the
this.
court is aware, is one that is extreme, and generally it would be appropriate when there has been some kind of harm and there has been some kind of bad faith. I'm not saying that that's the only time the court makes the decisions. Our argument would be that it should only be employed if there's something prejudice.
Yeah, I understand. So how is it not bad faith? And I don't mean this personally, but how is it not bad faith when you've been ordered by a court, probably orally and in writing, that you need to produce things as they come into being and as you know about them, and then you don't do that?
Bad faith would be holding it back for some kind of
I don't know why this is making me so nervous.
If we're saying we don't have to put that up until the last 5 witnesses, and we are at witness 80 in a list of 175, giving them the records or the plots now, literally when we have people,
Okay, so that sounds more like an argument that they aren't really prejudiced because they still have plenty of time to handle it, right?
It's actually for both, because what I was saying is, to say it's bad faith would mean that we held it back, or, I mean, that's still not the only definition of bad faith, but we did not hold it back for any,
Okay. You've done a lot of stuff that seems like it's in bad faith, Miss Love. To say you didn't hold it back. You like to skate around words, but you're not a good listener as well. The judge is helping you. The judge is giving you, Attorney Love, little nuances, little cracks. She's throwing little breadcrumbs out there for her to catch on to and give a better answer. She just can't do it.
Did I intentionally keep it from them?
Okay.
It's
So how is it that it came out on Monday or occurred to y'all over the weekend and you produced it on Monday? Is it because because y'all finally got together and said, all right, y'all, what else is there that we ought to be giving them?
She's again giving her crumb a nugget and she's not going to bite.
Why
I'd have bit all over
later?
it. Yeah.
so the moment that precipitated this disclosure.
Quit trying to use
I
big.
have to
She
I
love
have
to use a
rewind
big
and
word
go
when
back
she about to
over
lie.
everything that's happened. And I can only say that
Attorney Love,
it may have been
love.
at the court- I
She
know. It may have been
precipitated.
that as we were looking at
Child, she
30 witnesses
loves
out
to
there
use it.
looking at Bernie, we realized, oh, Bernie.
Attorney Love loves to use a big word when she about to lie. When she got to pull that thought together, boy, she pull out her thesaurus and she throw a word out there, boy. I tell you.
So it basically was just the court saying, it's time to get organized. It is time to share the details about what your intended trial evidence is going to be. That finally made y'all get organized enough to realize, oh shoot, there are some things we have not shared yet. Fair?
It is the court's order that got us to do that.
Okay. All right. So
She always give her a
that
pass,
is probably
though.
not bad faith. That is it being
See?
swamped.
What'd I
because
tell
there's
y'all?
a lot of evidence.
What'd I tell
But I
y'all?
am, and I am exercising patience despite the suggestion that I not do that. And I hear that you probably think enough patience has already been exercised.
Yes. Too much.
There is a long time before this witness is going to be called for this purpose.
This is ridiculous.
It is more difficult to prep for evidence as the trial is ongoing than it would have been before.
They had 2 years to prep. 2 years to prep. This is unfair.
It's more difficult to do it with 2 fewer months' time.
She's
than
another
it would have been
shield
with 2
for
extra
her.
months' time.
She might not coddle her like Glanville did, but she
This
keeps
needs to
giving
be
this
the
woman
last of it.
shield.
I mean, it's sort
She
of
is her
like
umbrella.
when somebody comes before me on a probation violation, and it's the first time I'm seeing them. I don't know what they thought about getting away with anything before that. But once I talk to them, I expect them to abide by it. I expect you to abide by it. So between now and noon
She
on
just told
Friday,
us she on
you
probation.
better make sure you have got all your ducks in a row and you have shared those ducks and ducklings with the defense.
Yes.
Okay.
She bites
I'm
her,
about ready to move on from this, but yes, ma'am.
but she doesn't give her a bite. She
Speaking
gives
to
her
your
a
mic.
nibble. Woo, girl, she just disheveled. She looked like Jesus. I need to breathe.
I believe that the state is arguing as if it's a first argument to you because they know you haven't been here for 19 months. These arguments, I've heard them so many times, it's countless.
I understand.
Right. And for the state to argue it's not bad faith, I'll give you an example of things that we've been through before we had the opportunity for you to be presiding.
Can I ask you a question before you do that?
Sure.
Is this something that is not already included in one of the numerous motions for mistrial or to disqualify these prosecutors?
I don't think so, actually.
You don't know?
I said I don't think so,
Okay.
but I'm not sure.
Go ahead,
But this
share
is
it.
specific about discovery, disclosure,
All right.
timely disclosure. The state's been caught before. Specifically, I remember a late discovery disclosure that once it was disclosed, it actually had a comment on there that was supposed to be internal that said, "Do not serve yet." They did it on purpose. And how many times can you say, oops? How many times can you repeatedly, systematically make the same mistake as an experienced litigator?
Yes.
And say, it's not bad faith.
Mm.
Your Honor,
Good point.
I'm just asking that the rules be enforced.
Yes.
Because if they're not really rules. They're just aspirational.
All right, I understand. And we are instructed ad nauseum by our appellate courts, they probably won't like my use of that term, that exclusion of evidence is an extreme sanction, and that prior to a trial court instituting that as a sanction, the solutions that need to be thought about include a continuance, which is not going to happen here because we've been on a continuance for a while here anyway.
Yeah.
A continuance here, it's, no, they cannot bring it up next week. It needs to be way far down the road, which they are representing that it's going to be anyway. So it'll give y'all time to look into whatever it is. And I understand what you're saying, and I hear you. And the answer to how many times can it happen? Maybe 0 more times. Okay.
It shouldn't have happened this time.
But related to this,
yes.
My understanding, I'm sitting way back here. My understanding is the state admitted some court exhibits to include the affidavit and the search warrant for Mr. Boyer's phone records. Is that correct?
Yes.
Could the state, we still don't have those. Okay. So could the state send those to us?
Can y'all share those by email, or should I have copies made of these?
And additionally,
it's sad. The judge got to keep doing her job.
We would also like all reports. The statement that the state has made is there's been a continued investigation into this case.
Hi, thank you for coming.
Boyer,
I appreciate your time.
Investigative reports, summaries,
hey,
supplements.
If you don't mind, leave a comment. Okay.
Reasonable.
Thank you.
Miss Love, you understand? Everything with regard to the police investigation of Mr. Boyer in any kind of involvement of his in any of the crime.
This is not going to be the only person that this happens with. This is a continuous cycle. And I don't know that attorney's name. I'm going to look it up before my next live, which will be later tonight, because we're going to talk about what happened earlier today. But she was so eloquent in what she said. This is an experienced litigator. She's not a lay person like you and me. She ain't somebody who just picked up some law books and heard some big words and was like, oh, I'm going to try to do this. This is an experienced litigator. Matter of fact, she is the cream of the crop for Fulton County. I'm just saying.
In this case.
But like they say, Georgia is that state where the saying is, come on vacation, leave on probation, because you just don't get a fair shot.
For it before the end of the day, and make sure you have it before, it should be by like sometime mid next week. And if it is going to be any longer than that, you let us all know why.
Always. She always gets a pass. She gets a carrot and a pass.
Okay, and so sharing the affidavit and search warrant and whatever else it was, is that something y'all can do electronically, or do I need to get copies made?
I'm actually checking to see if brought over.
She had the whole lunch period and a whole team where she know. Here's the thing. Miss Love knows how many attorneys are there. She knows how many defendants are there. She has a whole team. You tell me why she didn't send them up or downstairs, wherever it is, to make copies, to make sure everybody had a copy of what she had, because she didn't want them to have it. She wanted them at a disadvantage. She's praying, in my opinion, that somebody doesn't ask the right questions. And then she gets disheveled when the judge asks her the right questions. I don't know why she gets disheveled, because she just gets the pass to keep going.
So then we're at 159.6 through all of 160.
I'm so glad you guys are hanging out with me.
And I guess the objection is this is in. Okay. Now what's the state's response?
I promise y'all, I'm going to get better at this thing. I thank you so much for taking this time with me. I'm hoping you guys can hear me, but I do appreciate it. Thank you. Okay.
I changed my prior representation. I don't have an objection.
Okay. So that is out by agreement. All right.
So just, I'm sorry.
Go ahead.
Starting at line 6 on page 159.
Right. Yeah. Okay, so the next is 170, lines 10 through 17.
Okay, guys. I do have to go get this hair comb for my birthday tomorrow. So, again, I thank y'all for hanging out with me. Later tonight, I'm going to roll this thing back, and I'm going to be live, and we're going to talk about what led to this extra clump of coal that is in the YSL trial. Oh, wait a minute.
I'm not withdrawing my objection, but I would concede that this would fall under that same
All right.
reasoning that you've already admitted the other ones.
Okay. Thank you. Essentially, we don't need to re-argue it. Got you. Thank you. All right. So, my ruling as to this will be the same for the same reasons.
Well, guys, I don't really know how to work these controls, but again, I want to say thank you. And if you guys